Let's talk about the Spendthrift Trust. First of all, we'll talk about what it is, and then we'll talk about the pros and cons. Now, the Spendthrift Trust was originally a trust that one sets up for a person who has a history of reckless spending. The trustee has oversight of the use of the trust resources so the beneficiary does not squander his or her inheritance. More commonly today, professionals insert spendthrift provisions into trusts to protect assets from creditors. That is, the trustee can distribute funds to or for the beneficiary or beneficiaries, but not their respective creditors. The Spendthrift Trust is a legal tool for financial planning. Its slang name, Spendthrift, should not lead anybody to underestimate it. The Spendthrift Trust legal strategy can create unique value in the transfer of wealth as well as the preservation of assets during one's lifetime. Now, there are several versions of it. As indicated above, one can apply them to financial planning challenges beyond saving the family fortune from the reckless heir. And you can show you really care by clicking the like button below so YouTube promotes this video, and I'd really appreciate it. You can also click the subscribe button so that when more videos come out like this, you'll be up to date right away. There's been a growing interest in the Spendthrift Trust for these two reasons. One is the unprecedented amount of wealth which estates will pass along to the next generations during the next 25 years. Yet the RBC Wealth Transfer Study found relatively few among the beneficiaries feel they are prepared. For a specific group of these benefactors, the Spendthrift Trust can provide a proven passageway through the complexities and pitfalls of that process. It is also a way of bypassing the public ordeal of probate. The terms and conditions are private within a Spendthrift Trust. This can be important to families, like the wife that accused her husband of hating her family and relatives, and he replied, "No, in fact, I really like your mother-in-law." The second reason for the growing interest in the Spendthrift Trust is the litigiousness of the U.S. society. The boundaries between business and personal life have become blurred. Creditors, for example, rush to court to seize the personal assets of the owners of distressed businesses. And in civil lawsuits against professionals such as medical doctors or lawyers, defendants push for the right to attach their homes, their cars, and their stock portfolios. One version of the Spendthrift Trust, Domestic Asset Protection Trust, or DAPT, or Self-Settled Spendthrift Trust, can prevent that. And the Offshore Asset Protection Trust is even stronger, in fact, much stronger, for protecting assets for lawsuits. In addition, the Domestic Trust and Offshore Trust can be useful in providing for income and retirement, and when drafted properly, in reducing estate taxes. During the next quarter of a century, according to Cerulli Report, there will be a transfer of $68 trillion through about 45 million households. This is a common thread, but there are many different kinds of benefactors. Additionally, no two are exactly alike. There is a group among them facing soul-wrenching concerns which the Spendthrift Trust addresses. These concerns come in three forms. Irresponsible beneficiaries. Their children or somebody else they care about cannot handle the money. There is anxiety that the wealth they inherit will attract con artists who dupe them, or they can blow their way right through their fortune. They might marry the kind of spouse who can help them do just that. Like a man whose wife blew through the money says, "People always told me the first year of marriage is the hardest. Trust me," he says, "the last year is way harder." Special needs dependents. They have disabilities such as autism or bipolar disorder. A straight-out inheritance could make them eligible for Medicaid and Social Security supplemental income. Next, professionals targeted for lawsuits. There are also those future beneficiaries in lines of work vulnerable to lawsuits. That litigation can reduce the family inheritance to zero. A Spendthrift Trust can help prevent wealth from being plundered in cases like these. Okay, so what is a trust? Essentially, a trust provides the legal framework which assigns property to one party to manage for the benefit of another. The term property can refer to actual property, as 340 acres of land in Wyoming, but in law, it can also include investments such as stocks and bonds, patents, trademarks, and so on. What the trust sets up is a three-way relationship. The trustor or settlor or grantor. Simply put, this is the benefactor, the one who sets up the trust. In practice, it is typically the person who hires the professional person or organization, such as ours, to establish the trust. Second, the trustee. That is the institution or person whom the benefactor designates or the state law determines receives the property to oversee. And finally, the beneficiary. That is the one who benefits from the property in the trust. Primarily, it is the state statutory law which pertains to establishing and administering trusts. The laws vary from state to state and country to country, sometimes significantly. Therefore, benefactors might shop around for the state or country that offers the terms and conditions which are best fits for their particular situations. Nevada is on the top of the list for domestic spendthrift trusts, and Cook Islands and Nevis are on top for the offshore versions. And again, the domestic trust is not as strong as the offshore trust. In both cases, its favorable treatment ranges from not being subject to state income tax in Nevada to none of the usual processing fees offshore. In addition to the DAPT, only 17 states allow, or what some refer to as the selfie trust. These states allowing DAPT range from Alaska to Nevada. As with all state law, what applies in one state might be quite different from what is law in another state. And the problem is, the case law falls flat on its face if you live in one of those states that don't provide asset protection trust law. And since it's a domestic trustee, your local judge has the jurisdiction over the trustee and can order the trustee to give your money to your legal enemy. That's why domestic trusts don't work very well in practice in many cases. The strongest trusts worldwide that provide asset protection are those in the Cook Islands, south of Hawaii, and Nevis in the Caribbean, as we said. Our firm sets up more of these trusts than anybody in the world, and our trustee/law firm in these jurisdictions are not subject to the order of your local court. So if, for example, a U.S. court says, give me the money, the foreign trustee, aka our Cook Islands law firm, can say, you don't have jurisdiction down here, and the money is safe and secure. There are many kinds of trusts that people use in estate planning. They are not mutually exclusive. A benefactor can set up any number of them simultaneously. One kind could be for the offspring who has proved to be financially responsible. That particular trust could provide a lump sum payment for the entire inheritance. Alternatively, for example, the trust could distribute increments of 10% of the trust corpus annually over the next 10 years. No, not all heirs should be treated the same. For the less responsible offspring, there is the Spendthrift Trust. Initially, people created Spendthrift Trust to manage the transfer of wealth in a way that could give the settlor peace of mind. It ensures that the beneficiary will not be able to squander the total inheritance or be the target of predators or leave assets vulnerable to plunder by third parties such as creditors. Then Asset Protection Trust law took the spendthrift concept to a whole new level. That is, the trustee could prevent the enemies of the trust beneficiaries from seizing trust funds or creditors of the beneficiaries from demanding payment from the trust. That way, the beneficiaries can have a storehouse of wealth that the trustee secures beyond the reach of their legal enemies. The settlor puts property in the trust. When the settlor dies, or before, the beneficiary becomes another person. That person may or may not be a child or a blood relative. The beneficiary could be a loyal housekeeper who has little experience in managing money. Then, the benefactor assigns a trustee to manage the trust. Depending on the wishes of the benefactor and/or state law, the trustee could be an institution such as a bank or a person such as a lawyer, relative, or friend. But for the most pleasant experience and the strongest protection, the trustee should be a licensed, bonded professional trustee. The trust pays the trustee for such services. Some view this expense as a drawback of this financial instrument, but usually the fees are extremely reasonable. Don't like the trustee? Great. Fire them and hire another. Like the guy who was fired from his job as a zookeeper, which he really didn't think was fair. After all, he said, there were signs everywhere that said, do not feed the animals, so I didn't. Want to provide for your family for years without the chance they'll blow through all the money? The settlor custom makes the terms and conditions for how the funds are distributed. One popular version is the Lifetime Spendthrift Trust. This type of trust provides for the beneficiary for a lifetime. The terms can vary. Typically, there might be a monthly distribution to the beneficiary of, for example, $3,500 for the lifetime of the beneficiary. How the beneficiary spends it may be totally discretionary, or there could be a stipulation that it can only be applied to building a real estate practice in the state of Maine. Another possibility is that none of the $3,500 monthly distribution, adjusted for inflation, is given directly to the beneficiary. Instead, the trustee uses it to cover the bills for his or her daily living expenses. This is routine when the beneficiary suffers from addiction. No matter how the distribution is made, only these funds not the assets in the fund per se, can the creditor attach through collections or through the courts. Essentially, the principal remains untouched. Yes, creditors legally can go after the $3,500 monthly distribution, but payments can be structured to pay bills directly so this does not happen. That is why it is so important for those doing estate planning to understand this. And that's why an offshore trust is so valuable. Money is distributed to a secondary offshore account within the trust where the beneficiary has a debit card. The Spendthrift trust structure has flexibility. The beneficiary might make a provision that in extraordinary circumstances, such as a medical emergency, there could be a larger distribution or even a dipping into the principal. They will pay the bills. In addition, there could be a stipulation to only keep the trust in effect until the beneficiary is, for example, 50 years old or has been married 5 years. And over time, other applications have emerged for the Spendthrift Trust. These are three common ones. The offspring might be in a profession in which lawsuits are standard. The trust structure ensures that the inheritance will not be seized to pay verdicts and settlements. Or one can use the trust to facilitate a special needs child's eligibility for a needs-based benefit. This can range from Medicaid to supplemental security income, SSI, and this is done through a version of the Spendthrift Trust known as a wholly discretionary trust. The trustee has 100% decision-making authority about how much, if any, of the funds that the trust will distribute. Without Medicaid, the cost of the special needs dependent treatment and maintenance can decimate the family wealth. The trust can also prevent the courts from treating an inheritance as marital property. The trust makes it off limits in a divorce. In a sense, one could consider it a type of prenuptial contract, but put together on a unilateral basis. Traditionally, prenuptials involve two parties. So useful the Spendthrift legal framework has been that many estate planners routinely insert a Spendthrift provision or clause in other kinds of trusts they set up. What is important is the language or how the professional person words the clauses. Without the appropriate language, the courts could invalidate the trust. Okay, so here's an example of the kind of provision provided by Mary Randolph J.D., an article published in AllLaw.com. Quote, "Except as otherwise provided in this trust agreement, all payments of principal and income which as payable or will become payable to the beneficiary of any trust created by this agreement shall not be subject to anticipation, assignment, pledge, sale, or transfer in any manner. Nor shall any beneficiary have the power to anticipate or encumber such interest. Nor shall any such interest while in the possession of the trustee be liable for or subject to the debts, contracts, obligations, liabilities, or torts of any beneficiary. Furthermore, such interest shall also be free from any claim, control, or interference in the spouse of a married beneficiary or the parent of a beneficiary." There is an ancient adage that says, "Mankind plans and the gods laugh." And that wisdom also applies even to the legal validity of a Spendthrift trust. Despite the best efforts of the benefactors and the experience of the lawyer, there could be what is known as an invasion of assets, and that's why it's so important to set up an offshore trust instead of a domestic one. That is because reckless offspring could wind up exposing the wealth to access by third parties. Now, we've addressed many of the pros. Let's talk about some of the cons and some of the downsides of domestic Spendthrift trust. Fraudulent conveyance. Suspicions about fraudulent transfer. The protection of the assets only applies to legal action launched after an asset protection trust or offshore asset protection trust has been established. For pending claims by creditors, some states and countries offer a 1 to 2 year window for creditors to challenge the transfer of assets. This provision hinders fraudulent transfer behavior by the settlor. We must note that fraudulent transfer is a civil matter in general, not a criminal one. You cannot generally go to jail for it. It is simply moving assets so a creditor cannot touch them. With an offshore trust, a fraudulent transfer accusation is a moot point. They are mere words on paper that they cannot take your assets unless so ruled in the foreign court, in which there are skyscraper-sized barriers to doing so. Yes, estate planning is a complex field, as well as asset protection, both in terms of the law and the terms of financial conditions. It is unreasonable to expect those transferring wealth to become expert. But what is necessary to learn can be accomplished by asking a lot of questions. From those questions come knowledge of options. The Spendthrift Trust is one of those options. It can be used along with other estate planning and asset protection and financial tools to both preserve wealth and facilitate what benefactors want for their beneficiaries. Want to set up a Spendthrift Trust or want to know more? Give us a call at 1-954-400-1050 and speak with one of our attorneys or consultants, or fill out a free consultation form at assetprotectionplanners.com. Please click like, subscribe, and share this video with others. Thanks for watching. This is The Business Guy.